Good afternoon. Thank you for joining us for this last debate of the fourth International Normandy World Peace Forum. And the history of Normandy is closely linked to the idea of peace, of human rights, as this forum tells us every year. And it's a forum that is created to remember, but also to reflect on things. And today we'll be looking at international justice and its role with a question which is a bit provocative. Can international justice be the foundation of lasting peace? Is it really a foundation for peace? And we can have a debate on this. We'll try to reflect on how we settle and we try to manage tension, how we judge tensions, how we judge things in general in a more and more fragmented world. The 20th century was a century of many conflicts, very violent conflicts, that initiated a movement that enabled us to have an international justice that would judge on crimes against humanity, because crimes of that magnitude should not remain unpunished. So we'll have an ambassador today. Christian Venaveza is an ambassador for Liechtenstein at the United Nations, and he was also the chairman on the special group on the crime of aggression. He worked on the Statute of Rome for the CIP, and he will be talking to us from New York through video. One of the speakers today called you the world champion for international justice, so I hope you'll be a world champion for us. A quote that came from the United States. Richard Dicker is the director of Human Rights Watch's International Justice Program. And Human Rights Watch is an organization that have been advocating for justice and for an improvement of international justice. And we'll go back to you, Richard, on the emergence of these institutions and on how we can assess them and the challenges that these institutions are faced with. Among the organizations that have claimed for international justice was Ali Ouattara with his organization. And we know that international justice can be contested. It might remain blocked, but we'll see how it's very certainly a long-lasting work. Émilie Gaillard, you're a legal expert, you're a lecturer at Sciences Po, and you're the chairwoman of the Normandy pour la Paix organization as well, and you will talk to us about law and justice, and you will show us what challenges international justice has to face, looking at the right of future generations and how that could be implemented. And you've just published Legal Actions for Future Generations. It's the last book that you have published, and the Normandy for Justice Chair has just produced. And Thierry Crevelier, you're a journalist. You work for justiceinfo.com or .net, and you've been covering war crimes for the past 25 years, Sierra Leone, Rwanda, Bosnia, Cambodia, and you covered the trial of Vincent Labré in Senegal. So you have written on this as well, and you're a real specialist on the topic. Thank you very much for being here. A bit of history first. I'll turn towards the United States. Richard Dicker, you're in New York. So we have the UN Assembly with the withdrawal from Afghanistan. There's been a lot of work, I'm sure, in the past few years. First question is, how emerged the idea of these tribunals And how could international justice be implemented and set up?
Et merci. Malheureusement, je dois parler.
Thank you. Unfortunately, I'll be speaking English.
I want to thank the organizers for bringing us all together for this important discussion. I would say that in the early 1990s, after the end of the Cold War, there came about, on the backs of horrific tragedy and crimes in the former Yugoslavia and Rwanda, the creation by the United Nations Security Council of 2 ad hoc tribunals focused on those one region of Yugoslavia and the other ad hoc tribunal focused on addressing crimes in Rwanda. This was an enormous breakthrough, the first time since the Nuremberg trials at the end of the Second World War that there were international tribunals delivering justice for crimes against humanity, war crimes, and genocide. A year or 2 later, but in a very different process, the International Criminal Court Treaty began to be negotiated and completed. The difference being the negotiations took place with 140 states or governments involved, and these negotiations from start to finish lasted nearly 7 years. The treaty itself concluded at a conference in Rome in July 1998, where 121 states voted for its adoption. This created much more sense of buy-in, of participation from states around the world, which is how this treaty of the International Criminal Court, the Rome Statute, obtained the 60 ratifications or agreements by states that was necessary for it to enter into force. There are other courts that exist today, one for Lebanon, one for Cambodia, but the International Criminal Court is permanent and has potentially authority to address crimes committed anywhere in the world, depending on states agreeing to become part of its statute. Let me stop there for now.
Je vais vous laisser vous arrêter là, effectivement, et me tourner là encore aux États-Unis.
I'll turn towards the States. Thank you, Mr. Dicker. And I'll turn to Mr. Venaveza. We're talking about internal justice yesterday. We're talking about Nuremberg, a military tribunal. Mr. Dicker talked about that international justice that started after the Second World War. The idea of international justice is also the idea of punishing the criminals, the torturers, to recognize the suffering of the victim, to permit peace. Thank you for inviting me. It's a great pleasure to be here, and I'll continue in English as my friend Richard did from New York.
And thank you for the very generous introduction. It's a bit intimidating to be called a world champion in the country that has so many world champions currently, but a real pleasure to be here with you. I mean, indeed, I think it's important to link this conversation back to World War II. And no place could be more appropriate than the Normandy for that, obviously. So I think in some ways this was the beginning of effective international criminal justice, and certainly the Nuremberg trials do stand out. And I think it's easy to link this with the topic of our conversation today, because the European Union, of which we as a country, as Liechtenstein, are not part, but a very, very close partner, has, among other things, been called the most successful peace project in the history. And it is very important to emphasize this aspect of the European Union. And if we look back at the history of our continent, we of course all know that our region has been plagued by armed conflicts pretty much always until after World War II, of which certainly the European Union is a big part, but also, and in particular, I do believe the Nuremberg trials were a big part. So the Nuremberg trials certainly were a very successful example of illustrating the interplay between justice and peace, because for Germany in particular to be able to move forward, it was of essential importance to find closure with respect to the crimes that were committed by the Nazi regime in the name of the German people. This was a justice that was not perfect. It was a justice that was not complete, and it is in fact a justice process that in some ways is not even finalized at this point. You may have seen in the news media that the trials and probably the last trial with respect to Nazi Germany is still going on. But for Germany to move forward, for Europe to come together in the way it did, we needed the international military tribunals in Nuremberg, and this was, also planting the seed for much larger and more comprehensive and more ambitious efforts to have international criminal justice at the global level.
Merci, Monsieur Venneweser. Émilie Gaillard, je parle à la juriste quand on parle de justice internationale.
Emily Gaillard was talking to the legal expert. When one talks about international justice, what does one talk about? Just when one talks about international justice, there are several types of international jurisdiction. I start from 1945, when the states created the United Nations. They agreed around the charter, the San Francisco Charter, and the first words of that charter is to preserve future generations of the plague of war, because there was a realization that what humanity has just suffered was intolerable. And if you signed the San Francisco Charter, you become a member of the United Nations. And so, as such, all states recognize the existence of the International Court of Justice, and it implements the international law that is based on the difference between war and peace. And it basically implements public law for states. But then, as our and the speakers before me said, there was the Nuremberg trial because the circumstances was exceptional, so there needed to be an exceptional tribunal with the creation, if you like, of a term of that crime against humanity. But then there were more crimes like this later on in the century, so there were ad hoc special tribunals that were created, and then in 2002 there was an international criminal court that is permanent. And then there are special jurisdiction that are hybrid, and maybe Thierry can talk about this. And there's also international arbitrage where one creates a specific jurisdiction with specific mandates and specific arbiters that will try to solve an international dispute. So one can have a very we can have a very broad focus, or more specifically focus on the ICC. So let's go back to ICC, which is the only permanent international tribunal that can judge on genocide, war crimes, and maybe the crime of aggression. And I know that Mr. Venaveza has tried to define what aggression as a crime was. And so there were 60 states that had originally ratified the treaty. Now there's 120. So I'll turn towards Mr. Ouattara. It's a lot of work to have this to have countries ratify this treaty of the Statute of Rome. I'm sure. It's a work of trying to advocacy. It's a lot of work among the public to so that people understand what is actually at stake with that treaty. I want to thank my. I really want to thank you for inviting me. Thank you to my friend Richard Dicker, who's facilitated my coming here. The tribunal in Tokyo and in Nuremberg were tribunals of the winners. It was not. It was subjective somehow. It was the winners who created mechanisms to judge the people that they had defeated. And the special tribunals in the Rwanda or in former Yugoslavia was different. It was created by the Security Council, and there are tribunals that are limited within space and time. But ICC is not limited in time and space. It's not the tribunal of the winners. It's a permanent tribunal when and the state parties are free to join. So one needs to lead a number of the states to accept that jurisdiction. So it's work, it's advocacy work, and we approach various states. We try to get them to understand the necessity of adhering to that Statute of Rome, to that international treaty, because the fact that you join doesn't mean that the ICC will be meddling into the affairs of your state, because it is something that is not national, it's international. So once you ratify the treaty, the state needs to have a law of implementation to integrate that into its legislative body on the local level, whatever is at stake with the Statute of Rome, so that things can be judged on the local level, because the ICC might endanger the privileges or the immunity of leaders in a country. And so it's the independence of the state that can be at stake, which is not the case in practice, because it is. So one needs to explain that they need to ratify the statutes, and having that legal capacity, you can judge the very serious crimes that take place on the territory of the country. But it's difficult to convince states to do that. But I'll go a bit further, because the forum today has a question in its heart: or can international justice be a foundation for sustainable, durable peace? On the ground, what we see is that there are certain people who find that international justice cannot bring peace. As far as they're concerned, when there is a conflict, it is what you need to do is have reconciliation. There are victims, but you need amnesty, because if you don't do that, those who committed crimes can come back and start or generate more aggression. But in NGOs, we consider that if we want durable peace, we need justice, because that justice can right the wrongs of the victims and gives a very strong, it sends a strong message of the perpetrators of these serious crimes. And in one of my books, I say that today's impunity is tomorrow's crime. So impunity is an encouragement for the perpetrator to commit crimes again, and impunity is an encouragement for revenge, or an encouragement to revenge for victims. So it's a dilemma between peace and justice, but we say that both can be combined. Thank you, Ali Ouattara, for this explanation, and congratulations for the work that you do on a daily basis on the ground. We'll go back to Mr. Venaveza, who will have to leave us very quickly. Thierry Rivelier, you have also worked or dedicated your life to international justice in a way, because you took part in both debates on international justice today. But as a reporter, you've covered wars in Sierra Leone, in Africa, in the Balkans. You were very present as far as conflicts are concerned. But you also covered or followed what was happening in terms of international justice, because there's the time of crime, of the conflict, and then there's the time of the trial, and the time of the legal decision, of the judge's decision. So justice is important to victims, but it takes a long time for victims. It takes a long time, and it's a lot more complicated than what people existed in the early 90s, when the tribunals for former Yugoslavia or Rwanda were created. And since we're in the history of international justice, I want to lead you to current history, because a lot of things have happened since the creation of these tribunals by the UN took place 25 years ago. There was the international model with the courts that are set up very far from where crimes have been committed, with prosecutors and judges and coming from various countries, and not from the countries where crimes were committed, with the idea that can be legitimate, that it would mean that the justice would be more independent. But then one realized that these tribunals were very far away from the societies where that had been affected, that the justice was not really efficient, was more symbolic. And so one moved to more hybrid, mixed tribunals, where you had a mix between nationals and internationals, and one tried to go back into the countries where crimes had been committed, so that it would be more relevant for the public. And these hybrid tribunals were not very efficient either. And today we are in a situation where there's a crisis for this model of international justice. And what one can see, and what has seen for the past few years, is going back to something more national than an expansion of these national jurisdictions. Are very symbolic, but they judge very few people. They try very few people. They are very much disconnected from societies, and have developed huge bureaucratic processes that make them inefficient. So they are there, they exist. They are still part of the options that are available to societies that have just end after a conflict. And it's important that they are there, but it's not, to me, it's not the place where there's the most creativity in terms of justice after the war. And it's important to bear in mind that we had a period of international criminal justice, but it's declining for two reasons: internal, there's the dysfunctioning of tribunals themselves, and geopolitically as well. There's the window that opened in the 90s, but closed on the 11th of September 2001, and the Security Council of the UN are not going to create any more new tribunals. And so the justice taking place is more on the national level, it's more flexible, it's more creative somehow today for classical standard crimes, if you like, or, war crimes or mass violence. And I'm sure that Emily can tell us more about this, things that are more relevant to your generations. There are wars still, and there's dictatorship still, so we always need justice mechanisms that can respond to that, but we're also faced to other violence, into the environment, to migration, to the responsibility to the accountability of companies, indigenous people, or the colonial question that is certainly rising back to the surface, and all justice mechanisms. And I'll move on to transitional justice types of responses that are not necessarily criminal justice. There's a lot of ways to provide justice after violence, and all that field is extremely dynamic today. And as far as I'm concerned, it's more interesting and more connected to contemporary issues than big tribunals.
Des États partis, donc président des États.
Let's now turn to Mr. Christian Buenaventure, chair of the state parties who ratified the Rome Statute, which helped creating those jurisdictions. He fought hard to advance on those definitions, including aggression. Since countries have different visions, he worked a lot on this issue, but I believe he was disappointed several times. And Mr. Buenaventure, I feel like recently multilateralism, or at least the position of certain states around the situation in Syria, made you quite angry. And we will actually talk about complementary aspect of justice. You actually took a position in the UN in a firm way, which is quite unusual for a diplomat.
Oui.
No, I wouldn't say that. I think what we did was actually very diplomatic, but what we did was to say our view is we created the International Criminal Court to, investigate and prosecute exactly the type of crimes committed in Syria. That's what we have this court for. Unfortunately, it is impossible for this court to exercise jurisdiction. That is a sad reality. The Security Council of the United Nations is the only body that could create jurisdiction for the ICC in Syria, and it is unable to do so. It was proposed before the Council to take this decision, and the decision was vetoed by the delegations of the Russian Federation and of China. So what we did as a result is we thought about alternatives, and the alternative that we submitted to the General Assembly is a new mechanism. It's an investigative mechanism that is de facto a prosecutorial office. So it's an office that collects, preserves, and processes the evidence, and the evidence, sadly, is very, very, very vast of the crimes committed in Syria. Prepares case files that can be, the basis for a criminal proceeding in a court. So we did create what we call the IIIM, the impartial international investigative mechanism for Syria, which is a really novel form of an international justice mechanism. It is headed very ably by a French national, by the way, by Catherine Marcuel. And the mechanism has been very successful. and has been welcomed very widely by NGOs and very strongly supported by states. It does, of course, not fill all the gaps, because you still need a court that effectively puts people on trial. So what has happened is, and as the previous speaker has indicated, the shift in a way to the national level, and I think the shift to more creative, more innovative models. So a number of states, notably Germany, have taken it upon themselves to put people on trial in national courts in Germany who have committed crimes in Syria, and the Koblenz trials in particular certainly stand out in this respect, and in my view will be an important landmark in the history of international criminal justice. So we're very happy that we were able to do this, not so much out of anger, but just out of a sense of pragmatism and realpolitik, and in the quest for finding solutions, because we have to find solutions, and it's important to. I really want to emphasize what has been said by others here. International criminal justice is not the only form of justice that is necessary to ensure a sustainable peace. There are many other aspects that are complementary and equally important, and the model of truth and reconciliation mechanisms in particular has been crucial for societies to be able to come together again after it has been, after people have been going through a very traumatic experience collectively. So for a society to heal and to come together in a positive way and to be able to move forward together, that is equally important in my view.
Merci beaucoup.
Thank you very much. It might also be an opportunity to talk together about the limitations of this international justice, which is often criticized, a lack of means to investigate, to support the victims, veto issues, investigations being dropped around the British in Iraq, around the actions of the US in Afghanistan, which led many countries to talk about a two-tier justice, especially in Africa, Ali Ouattara, where it has been more and more difficult to hear the voice of an international justice. Thank you. Before I answer your questions, I would like to talk about what the ambassador said earlier. First, I want to congratulate him for the work he has accomplished, but I want to say that ICC has strengths and weaknesses. I won't talk about all the weaknesses, but one of the strengths is the Security Council, which can, through the UN, ask a prosecutor to open an investigation about a country where there are conflicts that have serious crimes committed. That's one of the strengths. But this provision, which helps the Security Council to ask ICC to intervene, is also a weakness, because the Security Council is a very political body, and it depends on the interests of the permanent member states who asks for those investigations to be open. And we saw this with China and Russia in the case of Syria. Plus, many of those members are not member states. So when those countries are not member states, Russia isn't, China isn't, they are the ones who will decide on that future. So it's a strength for peace, but it's also a weakness. The solution is to reform the Security Council, but that's another issue. With regards to what you said earlier around field work, what the ambassador said earlier is true. You need an alliance between national justice and international justice. International justice alone cannot ensure sustainable peace. It can contribute to it, but we need to make sure that national justice can also play its role. To caricature, it's like a chain where each part of the chain must play its role in order to make sure that there is enough capacity around the judges, but also to have national independence, impartiality, self-sufficiency, which can open the possibility to have fair and impartial trials so that victims can have access to reparations. As for national justice, the difference is that it's visible. International justice makes a selection. As for national justice, the people are closer to it, and this alliance is absolutely necessary, alliance between local and international justice to reach sustainable peace. Mr. Ouattara, you talked about those justice cases that progress but also require a favorable environment. There is local environment, political environment, the state of mind of the populations. Let me turn to Richard Dicker. Last week, Mr. Ouattara, as coordinator of the coalition for the African ICC, you launched an appeal around Guinea so that the victims of Guinea are not forgotten. And this appeal was also supported by Human Rights Watch, and they had also alerted on this a few weeks before. Richard Dicker, paying attention to those cases which seem on the right path, because the Guinean justice supported the investigation, but the fact that it was interrupted halfway through, is it additional work that must be done by international justice to support this national justice system?
I think that's an excellent question that highlights the complexity of bringing justice for the most serious crimes. And I would posit that really there are two lessons that I keep in mind from what has happened over the last 20 years. One is that world conditions change. And certainly, and Thierry was referencing this, world conditions have become less favorable, less supportive at the international level, as well as at the national level for criminal trials where these most serious crimes are involved. So we are working in 2021 on a different landscape than the one we saw in 1998, or I would say even 2005, 2006. The second lesson is that all the tools are needed. Rather than pitting one against the other or saying, this is better than that, I think it's clear that you need justice at the international level. You need justice by courts, as is being done in Germany, trying those accused of serious crimes in Syria, based on German domestic law. And then you need trials as the one that has been stalled in Guinea to go forward. All three channels are absolutely necessary and supplement and facilitate one another. I think what the Guinea situation reflects is the difficulty of bringing accountability through fair trial for the events that happened on September 28th, 2009, when Guinean military security forces killed scores of opposition party supporters and carried out scores of rapes of women attending that opposition party rally in Conakry. It's been 12 years since those events happened, and many of us have worked hard to see justice brought at the local level, and there are real advantages to that Thierry highlighted in terms of it being connected to the communities most affected by the crimes. But here in Guinea, to date, it has not worked despite all the efforts of so many, which could mean that the International Criminal Court, as the court of last resort, may have to step in, conduct its own investigation, conduct a trial, because the national authorities are unwilling to do what their responsibility dictates. So in conclusion, there's a synergy, not in opposition, between these different channels of justice, just as there is a synergy between criminal trials on the one hand, and as Ambassador Vennerbosser was stating a moment ago, truth-telling, purging security services of individuals associated with crimes. As Ali was highlighting, paying reparations to victims. You need as many of these tools working together to help heal the deep scars created by the commission of crimes against humanity, war crimes, or genocide.
Merci Richard Dicker. En préparant ce débat, vous m'avez parlé des défis, mettre la...
Thank you very much. When we started the debate, you talked about challenges, changing the strategy. Ali Ouattara, you talked about investigation strategies. You said that this very often challenges those cases and make them fail, which prevents justice from being served. I'll ask you to be brief, but could you elaborate on this? Thank you. Let me take the example of Côte d'Ivoire. You know that in Côte d'Ivoire, there were two belligerents in the conflict, Mr. Laurent Gbagbo, former president, and Mr. Ouattara's supporters. On both sides, crimes were committed. And Mr. Ocampo, at the time, the prosecutor, wanted to carry out investigations in segments. First, he wanted to investigate Mr. Gbagbo supporters and then Mr. Ouattara's supporters. That's a strategy that he tried, but now we see the consequences of this strategy. 3 arrest orders were launched. Mr. and Mrs. Gbagbo and its opponent. And as an NGO, we advocated for the prosecutor to make sure that this was done in Côte d'Ivoire. First, Côte d'Ivoire number 1, then number 2, and then they couldn't proceed supposedly due to an issue of resources. So Mr. Ouattara's supporters were not investigated, and these people, through the Truth and Reconciliation Commission, those people were promoted, meaning that the series of investigation can have a negative influence on the expected result. As for Kenya, where it was a balance, 3 opponents and 3 members of power. And recently we just heard in Afghanistan that this was also an issue around investigation strategy. The prosecutor asked to investigate only one party, the Taliban, and just dropped the case against the US, which delegitimates the process, which creates a justice of the winners. You rely on the power in place to investigate. So that's really the sentiment right now. In Côte d'Ivoire, people feel like there is a justice of winner.
Des vainqueurs, vous avez dit.
Thierry Crevelier, the justice of the winners. You followed a lot of these conflicts, of these tribunals, international tribunals, Bosnia, Cambodia, Sierra Leone, Rwanda. The justice of winners, is that a fair reproach? It depends. Sometimes the justice of winners can work somehow. Nuremberg had a number of aspects that were quite convincing as far as the justice of the winners is concerned. So I think one shouldn't be. I'm not sure that this is where things take place in a decisive way. It's more in terms of form. We've moved away from the justice of winners. We've moved away from the justice of the winners, but we've moved to the justice of the powerful through these international tribunals. It's very difficult to try the United States or China, France or Great Britain or India. These countries, Turkey, these countries will never accept to be tried in one of these tribunals. So these tribunals are essentially the justice of the powerful, but it can still be interesting justice and fair justice, or it may not be. But I think this is not necessarily crucial. It's not what's really at stake. It's on the impact or the relevance as far as a society where these crimes are being committed is concerned. That seems to be a much better way to assess a process of a judicial process. If it doesn't really matter as far as the society is concerned, one can question its point and its validity, or one has to recognize that it's purely symbolic. If the two main events today in terms of justice were national examples. Richard reminded us, and Mr. Ambassador reminded us that there's not only criminal justice in terms of response as far as justice is concerned. In terms of mass violence, the question of reparation is often neglected. The question of the search for truth is very important, and these truth commissions are very important. There's one in the Gambia, in West Africa, after a dictatorship, not a war, which was very spectacular. Something extraordinary for 2.5 years, with issues, with limitations, with biases, but also with a huge quantity of new information that came out after this truth and commission reconciliation, and Gambians lived for 2 years with that event on TV about what had happened for the past 22 years of military dictatorship. We'll see what can come out of this. But so I'll turn to Émilie Gaillard, because we've talked about the future, about transitional justice, something that you certainly believe in. And in a panel, Émilie Gaillard, as a legal expert, you believe in this, particularly because you want to have emerge an international legislation where one could clarify responsibility and save or protect future generations. A state, the Vanuatu archipelago, has tried to or has asked legal advice to the ICC on the consequences of climate justice, and it's the first consequence of your work on what international justice can become. Yes. More than on legislation, I work as I'm a researcher, and I'm trying to put forward a law that would respect the environment and also respect human condition. So protect the human species of projects like eugenicism or the change in terms of genetics. So we add a time dimension to current law, and that can be transposed to international law. And if today you endanger the future in a certain way, it's the precautionary measures, then one can decide that it's up to law to protect future generations. So we work in the environment and bioethics. Thus, the several types of studies we've been working on at the chair of the Normandy for Peace chair. I created a master's program in Rennes that's called Future Generation and Legal Transition, and the idea is give tools to students to new forms of thought, systemic thought, complex thought, to accompany these processes of transformation of law to protect the future within local communities, or maybe working as in charge of advocacy on the international level, and some of my students are here. And what we do within the Normandy for Peace chair, that's funded by the Normandy region, and it's work and under the auspices of the National Center for Scientific Research. And there's a number of researchers working there. The first thing we do is try to accompany that transformation process of fundamental rights, and it has a very concrete implementation. If you protect future generations, it means that we have to recognize that they have rights and we have duties towards these future generations. The Code of Cousteau had mentioned that about 20 years ago or more. It's something that was discussed at UNESCO, and with climate marches, people want the recognition of the rights of future generations. There were crimes against humanity in the past, but if you endanger the future, one can wonder whether one is not committing a crime against future generations. So we have duties towards them, and they have rights. And we're working on also on I Am Climate Justice, and a lawyer from the Philippines won the first legal action in favor of future generations, and he says the time for talk is over, and he launched an appeal that's been followed. Vanuatu has been the first state to pursue that idea with young people from the Pacific, and the idea is to say we will go to an international organization, the International Court of Justice, and we want a consultative opinion and advice. And the court is recognized by all member states of the UN, and one can submit a case. And young people around the world are marching for the climate, and they can go to the Ministry of Foreign Affairs of their state, and there's a national coalition called ICGAO that is coordinating under the aegis of Solomon Yo, who's the young man at the head of that international campaign, who's in the Pacific. And Solomon is, but because the International Court of Justice rules or has a look at law, between states, and Vanuatu decided that it would be a leader on that level, and it's up to us to amplify that work of scientific diplomacy, to go and see European members of parliament, to try to convince states that are partners of the European Union, try to convince Ministry of Foreign Affairs in France or elsewhere, and we will have a presentation at the UN among the permanent delegations of the UN, saying that yes, you should go and see the International Court of Justice. And there again, the idea is that we're asking a question to the National Court of Justice, a very simple question, which is the most legitimate court to talk about future generations, and we'll ask what are the obligations of states within international law to face climate change, because the approach is not only centered on human beings, it's not anthropocentric, but it also takes in a very an aspect which is the respect of the environment. So the idea is to establish responsibilities. So the Vanuatu was hit by 2 cyclones in 5 years and considers itself a victim of climate change. And Vanuatu is considered that it's not being helped as far as its fighting climate change is concerned. So the idea is to establish responsibilities. What would be the response to what would happen what can we do at the UN in 2022 to raise awareness? More than reparation, what we want is that states act more. If we don't want, to us, the idea is that we need to anticipate disasters and anticipate the rights of future generations. So we've got something in Geneva taking place as well. Last year, the Council of Europe recognized the right to a healthy environment on the world level. There's a tidal wave with these actions against states, against multinational companies. We see there's a demand for climate justice, and it's happening now. And our youth can play a major role in this. And what we want to do is position the International Court of Justice and to force the court somehow to respond. We're asking a question. We're saying the climate crisis is something urgent, and it should be more important than the economic right. Mr. Venaveser in New York, will that bring you more work with what happens with the right of future generations? A lot of diplomacy there. What is your opinion on this, beyond the fact that it might create more work?
This is what international law is for. It is really important that we look at the legal aspects of it. Of course, it's a bit of a paradigm shift in a way, but the conversation is there. There is the term climate justice. There is also the term intergenerational justice, and I really think we have to deal with these matters. Climate change is the biggest threat to us. People usually say to the planet, but it's actually more to the change to us. The planet is not going to die. We are going to die. And it's something that we really have to effectively address. And I think it's very important to look at the legal aspects of this and to ask the question, that is considered right now. There are other initiatives on the way also, from people that make suggestions in the framework of the Rome Statute. That means in the framework of international criminal justice, which of course, you know, ICJ is not doing. So there are proposals to amend the Rome Statute to include crimes against nature and a crime called ecocide, and that of course will be for us a very, very challenging and important discussion to have if and when it reaches us. So you're certainly right. We have a lot to do, and I really want to comment my colleague on the podium for her initiative and for her really great presentation of the topic.
L'écocide devant la CPI, c'est quelque chose.
Ecocide in front of the ICC, is that possible? Ecocide being tried in front of by the ICC, is that possible?
That is being proposed. It is at a very, very early stage. It's not even formally before the states parties yet, but a group of very, you know, very renowned scholars and academics have taken it upon themselves to put the proposal together. So this is the stage that we are at. So it's certainly something that would be very, very controversial and difficult and would take a long time to discuss.
Émilie Gaillard, ça ouvre des portes.
Émilie Gaillard, does it open avenues? Yes, it's true for the ICC. There will be, and there are other things happening in Africa, United States, and so forth. So it could happen in many circuits, if you like. But Stop Ecocide has launched a national campaign after the work of Polly Higgins to recognize the crime of ecocide, a crime against nature, and also future generations, but not only. And what's interesting is that in 2016, the prosecutor of the ICC, and wasn't mentioned at all, but there can be also people's tribunals. And I was taking part in the citizens' tribunal against Monsanto, or the people's tribunal against Monsanto, and the ICC prosecutor said that one should reflect on the extension of the capacities of the ICC to all crimes against humanity or against land grabbing. Because there are a number of states have recognized the rights of nature. There's the idea of the idea of the ecocide. It's something that was envisaged when the status of the ICC was drafted, but it was then erased. And Vanuatu once again is a leading state to impose that idea. And experts like Philippe Sands, for instance, have been discussing, and I think it's important to federate the community of academics, because one cannot have these reforms of international conventions by working with states and by having the support of civil society, because for states to change or to change their position, civil society needs to be involved, and the youth could certainly convince states to change. I'm sure that we'll give the floor to the youth in a second, but I'm turning to Richard Dicker, the concerning climate justice. You, as a defender of the rights, does that mean that you add the rights of? Does that mean that you will be defending climate justice as well? And you're a defender of rights, or an ombudsman. You're an American, and as an American, but how can you manage being an American and reflect on climate and on international justice?
Well, several questions there. Let me take the last question first in terms of being an American, as I am, and also being an advocate for justice through international courts when that is necessary. I think it requires me and my colleagues to recognize a very basic reality that we have touched on in our conversation, but not really addressed directly. That being, justice through international courts is not applied evenly to all. That is a reality that reflects the disparity in power, militarily, economically, and other ways. Several panelists, I can't recall if it was Ali or Thierry, alluded to this. Is the ICC a vehicle for justice by the powerful against the less powerful? And I think the reality is that states such as the Russian Federation, the People's Republic of China, the United States, Turkey, India, Saudi Arabia, and one could name more, have not joined the Rome Statute regime, so to speak, whereby the ICC authority is pretty much applied on a consensual basis. That means the ICC has authority where the state on whose territories the crimes occurred has joined the Rome Statute. And unsurprisingly, all the states I just mentioned, and a lot more, have not wanted to subject themselves to international justice. The challenge that creates for me as an American is to acknowledge that and fight like hell to change that. Not to accept that as a permanent feature and work, as the late Martin Luther King said, to bend the arc of justice to more even application across the globe. And I'll stop on this point. That was the basis of excitement to see the International Criminal Court move out of its exclusively African focus and have the prosecutor, Fatou Bensouda, whose term ended in June, announce the start of an investigation into crimes in Palestine, into crimes in Afghanistan, and possibly into crimes committed in the Ukraine, where Russian individuals could be implicated in serious war crimes. So I think as an American, it's a responsibility to help extend this reach of justice to those states, particularly the United States, that hold themselves out as exceptions. And we've got work to do. The Afghanistan investigation offered the first possibility of that, which is why the new prosecutor's statement just this past Monday, announcing he would focus exclusively on crimes committed by the Taliban and ISIS, I think was so ill-conceived. Briefly on the second point, I think ecocide does need to be given legal definition, and once that definition is generally agreed on and a means of triggering that crime, I think it would be an obligation of states to the Rome Statute to consider its adoption. I think it will take time, but I think justice is an evolving doctrine. It's not static. And I think Ambassador Venabasser demonstrated with the definition of the crime of aggression and the means to operationalize that within the ICC, an effort he led over many years, that things can change. And I would expect there is plenty of basis for extending the jurisdiction of the court once proper definition is reached, and then it would go to states for negotiation, which will be difficult in its own right. Thanks so much.
Merci Richard Dicker. On va passer à vous.
Thank you, Richard Dicker. Let's now move on to you, Thierry. You'd like to react. Yes, about ecocide and environmental crimes. It's very important around what's happening at international level and the debates amongst legal experts. It's an important debate, but you can see how long it takes. You can see how heavy the process is. But things are already happening at national level. There's much less media coverage, but just last week, a small military tribunal in the west of Congo ruled against a former soldier who became a militian, and he was sentenced for crime against the nature, for the damages against the natural park in the region he is in, and which he uses to get money to pay for weapons. So this is a Congo military court that works in incredible conditions, but develops a right of nature and the right of environment in a small court. Actions against climate change, Emily knows it, has already been covered by certain NGOs in the Netherlands, in France, who had states sentenced for not holding their promise around actions to limit global warming. So this exists. It's progressing in quite a specific way compared to legal experts' debates. Thank you, Thierry. It's now time to listen to some questions from the audience, questions to the panel. Mics are being circulated. Talking about ecocide, 30 to 40,000 deaths per year due to terrorism, but 10 million per year due to climate change every year. A few questions maybe before we conclude? We have one question. Hello, thank you for the quality of the debate. I had a small question in this context of crisis of international justice. Could mediation be an alternative? We saw its implementation in countries like Israel, in Rwanda, Sri Lanka, or other countries. Is this something that can bring creative solutions, as mentioned earlier? Could this help a better access to justice and therefore to peace? There are so many different methods that all of them could be used in specific contexts. Mediation can sometimes be more useful in order to end a conflict or to put different parties around the table more than a post-war justice mechanism. But it can be very interesting, of course. Why not? It's one of the tools. A concept that I mentioned during the previous panel that we should keep in mind. The type of justice you can get after a war depends on how that war ended. If there's a negotiation, then justice will come from that compromise as well. That's how it works, because the priority of a peace agreement is to put an end to violence. So I think mediation is more before that process in order to reach a peace agreement. Next question. Sir. Good evening. Thank you for this great debate we just heard. I have a question because the topic that we are talking about pushes us to ask questions. I went through this in my country. I am from the Sahel, from Niger. And when we talked about international justice, I heard your interventions, and you are yourself convinced of the relevance of this international justice system. Right now, we are going through chaos in Sahel. But who is responsible when more than 1 million accounts are being closed? Children are on the street, and those responsible for this here have their children in school. So I think the international justice could look into this. I thought I would ask this question to Thierry. Do you think it's normal that this justice is powerless and that it want to put G5 under Chapter 7? That is a request from our head of states. We are going through this crisis, we can manage it, but we need the solidarity of justice. If today we are present in Normandy, it's because France, and the Normans of course, enjoy the solidarity from the English, from the Canadians, from our grandparents who came to help them. So we need this solidarity as part of this justice system. These are my questions. I hope you can answer them. Thank you. Mr. Dicker, Mr. Van Aviser, maybe?
Because I really have to leave, but I want to thank everybody for including me. Thank you so much.
Merci, Monsieur Van Aviser, et merci d'être resté longtemps avec nous. Monsieur Dick.
Thank you for staying with us, Mr. Dicker. Thanks again.
I would just start by saying I don't think international justice is powerless. However, it does not have at its disposal a police force. It cannot deploy officers to arrest individuals. And that has been true of the earlier country-focused tribunals. It is true of the International Criminal Court. And that is a real weakness in its function. What that requires is greater support, greater cooperation by other states that are signatories to its statute. On your first question, could the chaos you're referencing in the Sahel and Niger possibly become a matter that the International Criminal Court would examine? I think it would depend if there is conduct that rises to the level of crimes against humanity in the chaos that you've described. If there are widespread or systematic killings or acts of torture being carried out in furtherance of a state policy, there could be an argument made that crimes against humanity are occurring. But the ICC has a high and strict threshold in terms of those crimes it can exercise its authority over. So investigation, legal analysis would be required. I don't think the ICC would be able to take up instances of the kind of broad chaos you're talking about. There would have to be crimes against humanity or war crimes. Let me stop there and leave it to other panelists to speak to the question.
Ali Ouattara, peut-être, en attendant une autre.
Ali Ouattara, maybe? While I would simply like to say that there are too many expectations from these countries. There are too many expectations, so although the ICC can generate hope, there is too much hope. It has limitations, it has strengths and weaknesses. It complements national jurisdictions, so people should take this into account. The regalian power of a state is to make sure that its population lives safely and that there are fair trials. ICC comes as support, and as Richard said, it's a last resort option. So you need to rely on national justice first. With regards to peace, there is an aspect that we haven't talked about. That is the cultural aspect. That is fundamental. Although certain mechanisms exist, the population must have a culture of peace, of respect of human rights, and also a sociologic aspect. And Guinea is an example. When leaders make constitutional reforms to change the constitution to get a third term, then of course, this is a sociological aspect, which is part of some sort of constitutional coup. When you have this type of behavior, of custom, you cannot get peace. So even though the African Union Criminal Court condemns such a third term, so we can now say that the African Union failed. So there are, of course, challenges with the ICC, and amongst those, being accepted by everyone, especially around its impartiality. Too many expectations, and this culture of peace is not present enough. Too many expectations towards ICC, for sure. Way too much expectation. The debate should be on a different level to be more reasonable. But once again, what the ICC could potentially do is so minimal, so symbolical, that giving so much expectation is a recipe for disappointment and disillusion. So I think it's necessary to keep this in mind and not put this court on such a pedestal. That's a first thing. Secondly, be careful. A court never stops a war. Justice does not stop a war. So once again, depending on the priorities or the challenges in place, that's not the right answer. A war or a conflict either ends through the victory of one of the parties or through a negotiated peace. And if there is a solution to a war, it's not justice, it's to end violence, it's peace. Justice can be a component of the negotiation, but it's not the object of the negotiation. So I think it's necessary to put things back into their natural political order. Thank you, Thierry Cruvelier. More questions, maybe? If not, then time has come to end this last debate of this 4th Normandy for Peace Forum. Thank you, Thierry Cruvelier, for accepting our invitation, last-minute invitation, but I think it shed some light in this debate. We want to thank you, Christian Venavesser, although he left already. Thank you very much, Ali Ouattara, for your daily action in the field. We know that this field action is crucial. Richard Dicker, Director of the International Justice Program at Human Rights Watch, thank you for taking part in this panel, for organizing it, and for suggesting names to us. We hope we will see you again in Normandy when justice brought peace again. And thank you again, Émilie Gaillard. You are the local actor here because you have your chair here for the next generations, the Normandy for Peace chair. Let's remind people of your book, Legal Action for Future Generations. It's in English, so Richard Dicker can read it, although he can read French too. We will soon get a French translation, an updated version. Thank you for coming. Thank you for your loyalty, and see you soon.